Hello everyone and welcome to our Women in Sectional Title webinar. We use this platform to share knowledge and skills in our sectional title industry, as well as to provide support in the form of webinars about health, burnout, stress, and other interesting topics which are food for the soul and which we feel are incredibly important for the well-being of all women in the sectional title industry, trustees, managing agents, developers, real estate agents, all of us are in the same boat. This is, can you believe, our 65th webinar, which is a fantastic milestone accumulating in just over 5 years of this WIST initiative. Thank you for your kindness. Thank you for your support and your engagement. We are always much stronger together. A proactive approach is always necessary, and now more than ever, we need to support our stakeholders, and most importantly, our regulator, being the Community Scheme Ombud Service. We are so happy to welcome a new sponsor for our WIST platform. Thank you to the team at ASI Best Sure. They offer sectional title insurance with tailored risk management and insurance solutions. When I was lucky enough to be invited to their offices in Bryanston, I was really blown away by their dedication and their focus. Their vision is to be the most significant financial services insurance company in South Africa. And I think they also strive for long-term relationships with their clients and business partners. So we love that ethos, and we look forward to a partnership of synergy, energy, and a wealth of knowledge sharing and abundance. So to all of you who are on this website from ASI, welcome. Really happy to be here, and our door is always open for whatever questions you might have going forward. If you want to know more about ASI Best Sure, you can go to www.asibestsure.co.za. Of course, to our fabulous loyal sponsor, WeConnectYou, who's proudly South African company specializing in developing software solutions for the property management industry. Thank you to the team at WeConnectYou, are committed to developing superior solutions, enabling seamless take-ons, and providing dedicated training and support services. We appreciate your loyalty and support, and I personally look forward to being online at the WeConnectYou Engage event, which is on the 6th of February. Watch this space for more information. I'll also be present at the online events in both Durban and Cape Town in March. So I think that's going to be exceptionally interesting, and it's going to put the focus back on managing agents, which I think is going to be awesome. So for this webinar and the next two, we're going to be refreshing your knowledge, grounding our core sectional title principles, resetting, recalibrating so that our foundation of knowledge is always very strong. We should all know that on the 18th of July, 2025, last year, the Community Schemes Ombud Service issued a voluminous document, the Consolidated Practice Directives 1 of 2025. It's 218 pages and pretty intimidating to any of us, to say the least. They were signed off by Kedi, Abe, Malesatsi, and Mervyn, the top management team from the Community Scheme Ombud Service. So today and for February and March, I want to guide you by taking your hand and talking you through the structure of the directives and the content, which I know will interest you the most. I'm dedicated and determined to choosing what applies to you. What practical tips can you take away from you? Where are the cautionary warnings, the orange lights? Where are the happy moments in this whole thing, the green lights? And where are the interesting sort of corporate governance points that you need to mindfully note? I will be using AI today to take notes, to send a summarized version of this webinar to you, as well as a digital version of the directives in case you don't have it. I think you do need it. So these practice directives apply to all community schemes, sectional title, HOAs, share blocks, retirement developments, companies and housing cooperatives. I think many people thought these directives in some way supersede the sectional title legislation, but they do not. They're there to partner with the legislation. And where do they come from? Where do these directives come from? They're born out of Section 36(1) of the Community Schemes Ombud Services Act. So that's where the root of these directives lie. The Chief Ombud actually must issue practice directives with regards to any matter pertaining to the daily operations of the CSOS of the service. So practice directives must, subject to the Act, direct the performance of any act in the operation of the service. Put another way, practice directives are official guidelines or instructions issued directly by the Chief Ombud to ensure consistency and effective handling of registration of schemes, compliance, governance, and disputes. So green light here in the middle of everything, an easy to understand way to put it for you. The Act tells you what the law is, but the practice directive tells you how the CSOS expects you to obey the law. And a practical tip, if you are a portfolio manager, a CSOS official, or the chairperson of your body corporate, my advice to you would be to print out the CSOS practice directives. There you go. I've got a copy on my desk. Print it out, hard copy. Keep it on your desk together with a book, either Demystifying Sectional Title, which I co-authored with Corinne Blaze, or obviously Paddock's books or Track's books or whichever books that you have. I've also printed out the Community Scheme Ombud Service Act, which I've bound, very important, and the Sectional Title Schemes Management Act, which I've bound. And this makes life so much more so much more accessible to information and so much easier for you. So I would suggest that you guys do that for reference purposes, important. So let's start breaking down this huge document and grappling with what it contains. So the introduction and disclaimer, which is at the very beginning, basically tells us which community schemes are covered. I've just mentioned them. And that very importantly, that these directives cover all owners in the schemes and who occupy the schemes, tenants too. And for the managing agents on this webinar, it applies to all persons who manage community schemes. So this may make you a little bit vulnerable from a legal point of view, because you as managing agents are not able to opt out of these consolidated directives, and ignorance of the law is no excuse. So whatever information you're providing to your schemes, you need to know this backwards. These consolidated directives are like your Bible on your desk. So orange light here, cautionary warning. What they say as well is that these CSOS directives are subject to change. They are busy with enabling legislation and amendments to our sectional titles legislation as we speak. And so what they're saying to us is that we are all advised to keep checking the CSOS website and any official publications for any changes to these practice directives. The directives, they say, are not creating conflict with legislation, and that the directives supersede all those previous directives. You'll remember you got those, did you print them like I did? Print them and try and put them in a folder and try and keep up with them. And to me, they were very confusing. So I think these directives will ensure consistency and alignment with all the current standards and objectives of the Community Scheme Ombud Service. Right, next. The definitions come next in that great big document. And they include all the usual definitions that we are aware of about Sectional Title Schemes Management Act and all those definitions. The one new thing, which I thought you guys might find interesting, is they talk about dual schemes. So you know those duets, those schemes made up of 2 units, which are quite prevalent in places like Pretoria in Johannesburg here. Those duets are now called dual schemes. And the Consolidated Practice Directives make it very clear that they are subject to the Sectional Title Schemes Management Act and to these directives. So that's important too. CSOS loves acronyms. The Ombud Service on page 17 in their practice directives list in detail all the acronyms that are found in these Consolidated Practice Directives. The ones which I think you should become really aware of are CEI, Compliance and Enforcement Investigator, CMO, Case Management Officer, a QAC, Quality Assurance Certificate, and an SGO, Scheme Governance Officer. I would say holds a very important place at CSOS. Next up, CSOS outlines 16 acts and one incredibly important and heavyweight document, which has direct impact on the successful implementation of the directives. So, while I go through the acts, I want you to think about and pop into the chat box what you think that incredibly important directive actually is, the document, not directive, is. First act, Community Schemes Ombud Service Act, Sectional Title Schemes Management Act. Then we go into the Sectional Titles Act. Just briefly, and I want to interrupt here because there's still people who are not understanding the difference between the Sectional Title Schemes Management Act and the Sectional Titles Act 95 of 1986 as amended. So when the new legislation came in 2016, on the 7th of October 2016, the Sectional Titles Act, which was my very good friend, because in those days that's the only act that I looked at, had all the consumer-driven clauses taken out of it and placed into the Sectional Title Schemes Management Act 8 of 2011. And it was left with the rather boring and dour provisions of like conveyancing things, but it still exists. And I go back to that Sectional Titles Act to look at things like Section 24, which deals with extensions, or looking at Section 25, which deals with phase developments where you've got the right to extend the scheme, or definitions of exclusive use area. So there's still a lot to be said for that Sectional Titles Act. Then we look at Share Block, Housing Development Schemes for Retired Persons Act, South African Cooperatives Act. The Companies Act is set out here in the Consolidated Directives, but be careful because the Companies Act does not relate to sectional title, and it does not refer, or in any way it's not, you can't apply the Companies Act to the Sectional Titles Act. So in this context, the Companies Act relates to homeowners associations and share block schemes. The one word that you know very well in sectional title is fiduciary duty. That comes out of the Companies Act, but it still doesn't mean that the Companies Act's got anything to do with sectional title. Public Finance Management Act. Number 9 out of 16 is the Property Practitioners Act. And that is an incredibly important act and governs very much of the way that you deal with daily life as managing agents who are sitting on this platform. The National Credit Act, the Banks Act, the Legal Practice Act, Disaster Management Act, which we're going to talk about, and of course your Protection and Promotion Act. So it's the Protection of Personal Information Act, your Promotion of Access to Information Act, and your Promotion of Access to Justice and a Promotion of Administration to Justice Act. So those are those 3. So anybody got any idea of the really, really big heavyweight document that I was talking about that applies to sectional title and to these directives? Nobody? Okay, then I'm going to tell you. The Constitution of the Republic of South Africa. Without the Constitution of the Republic of South Africa, the sectional title legislation is really nowhere, because that is the source document of a lot of the law that has been legislated. Okay, so we're talking now about we're going now into general guidelines. So this is where we go after all these acronyms and what acts apply. And the guidelines say that the body corporate or all persons seeking help from CSOS have got to adhere to the following guidelines. Orange light, caution. The CSOS governance officer cannot complete application forms on behalf of the applicant, nor can the officer instruct the applicant on how to complete the form unless that applicant is unable to read or write. I have to say, I've had quite a few instances, maybe not so much lately, but at the beginning of the CSOS, where people were going into CSOS and the officials there were almost giving legal advice and putting everything in writing for people and having consultations and that type of thing, which is not what the CSOS mandate is. Also, just something quick to have a look at or to note, if you go onto the CSOS website, you'll also see that there is a new dispute resolution model that is coming out now in January. So just keep your eyes open for that. The guidelines continue to say that English is always the preferred medium, but that the CSOS are aware that there may be language difficulties, so they will make a plan to translate. All interactions with the CSOS must be courteous, polite, and respectful, and timeframes must be adhered to. And all parties to a dispute must receive the documents to be used as evidence. So it's no good you saying or relying on a certain document in dispute resolution and then not giving it over or handing it over from an evidentiary point of view. Something interesting. Parties must exhaust all internal dispute resolution mechanisms available in terms of their rules. Now, you all know that if you are familiar with sectional title. But what does it mean? The practice directive is extremely strict about this. It says they must exhaust all internal dispute resolution mechanisms available in terms of their rules. So is it in the rules of the scheme, the schemes that you manage or the schemes that you run as trustees? Are those internal dispute mechanisms put in place? Because also it goes on to say there must be evidence of such attempts before things go forward. Now, I'm not sure, to be very honest with you, how much this is utilized at the CSOS. Do they insist on this? I'm not sure. If you've got any experience with this, where they come back and say, please show me evidence and your rules where you've exhausted all the internal remedies, let's have a look. But that is what the directives say they have to do. Also, obviously, this doesn't apply when there's urgent interim relief that you need, that you seek. And I'd also like to know, what is your experience with the CSOS with urgent interim relief? How urgent is urgent? And do they take it seriously about urgency? So again, guidelines, the CSOS mandate is for its officials to guide and support. The support does not include giving legal advice. Okay, the directives now also go on to set out the details about the CSOS officers, such as their phone numbers, their addresses, and all the email information. And just to refresh all of us, and for me, this is also a great learning curve and a way to just get to the forefront of my industry. 3 regional offices in South Africa. So we've got Gauteng, we know the head office in Centurion, in Natal, and in Cape Town. And something that I think you would find interesting is that Cape Town are looking for new offices. The tender to supply new office space for the Cape Town office closes on the 9th of February 2026. That is to rehouse the Cape Town Ombud Service for the next 5 years. And it's interesting for me as well, because in Gauteng, I remember all those years ago when the Ombud started, going to their offices in Sandton and walking through the almost like Warren-like corridors to go and find the chief ombud who had originally been appointed, all the way sitting by his lonesome at his desk at the ombud's office, supported by a CFO, the chief financial officer, and thinking, gosh, these guys, it's like a monolith ahead of this team to go forward. And look where they are today. I mean, it's been 10 years. Some things are still not great. But again, we must offer our support and make sure things do work and things do happen by being critical and helpful at the same time. So 7 satellite offices I forgot to mention: Ballito, Polokwane, Kebeja, George, Mbombela, Bloemfontein, and Rustenburg. So all this information precedes chapter 1, which we're going to deal with right now. So chapter 1, we go on, talks to registration of schemes, compliance, and enforcement. And if you had to ask me, or if your client had to ask you, one of the trustees in a building that is not registered, for example, says to you, but where is the law? Give me the section of the Act, or give me a regulation, or give me a management rule which says that you have to register all these schemes. Where would you find it? So write this one down, although I will be sending this. Under Regulation 18.3 of the CSOS regulations, states that the community schemes are mandated to be registered with CSOS. It's not optional. We know there's no fee to register, and once the scheme has registered, it will receive a scheme number and a registration certificate. Now, most of you are aware of this. Orange light, big, bright, shiny orange light. According to the CSOS 2024-2025 reports, as at the 31st of March 2025, there were 37,613 community schemes registered on the CSOS database. We estimate that there are close to 70,000 community schemes in South Africa, which means that there are around 46% of the schemes remain unregistered after 10 years of CSOS existence. The bottom line for me is that the CSOS need to get the banks involved to ensure that every scheme in the country is registered. My view, and I've been bashing on about this for many years, is that until such time as the banks won't give bonds in complexes which are not registered, or won't allow a sale to go through in complexes that are not registered, we're going to see this very, very slow plod. I mean, I don't think 46% remaining unregistered is a good thing. And I don't think it's going to be hard to implement. Our conveyancers at our firm would be able to say, without clarification of your registration certificate, we're not registering. Just like they say, we're not registering without a compliance certificate for arrear levy, arrear levies. So I'm not sure how you guys feel about that, but our senior manager on governance, compliance, and enforcement at the CSOS agrees with this view. And when I last chatted to her, she said that she'd already made recommendations in her report about this. So hopefully the CSOS officials will sit up and listen to that. Once an application to register a scheme is made, we know that the CSOS has 7 business days after receipt online or of the forms, because we still deal with forms, to register the schemes. On the CSOS website, there's a call to action. Don't waste time. Register your schemes today. Visit CSOS Connect now. Remember, schemes not registered are breaking the law. What law? Regulation 18.3 of the regulations, so that we can say that. My view again, and I can't say this enough, is that the CSOS approach to registration is not strict enough and way too consultative. They advise in the directives that they take a dual approach. Firstly, it's a non-punitive step of direct engagements and informal mediation. But why? Why? The law is the law. The law's been there for 10 years. They've had it's been quite an indulgence giving people this. But the last resort for CSOS, which they don't use at the moment, is to refer non-compliance to the National Prosecuting Authority, who would have the option of setting a fine or jail time. So Sandra says, Marina, side question, council also plays a role. They drag the clearance certificate on for sellers, drags on longer than a year as they make interest profit. Yeah, I think you 100% right, Sandra. I think from that point of view, also a major, major problem. And I know even speaking to our conveyancers 2-3 days ago, they're battling with clearance certificates, they're battling getting rates, assessments and things like that. So yeah, everyone's got to get the act together. It's about time now. Okay, nice little green light for you in the midst of this doom and gloom. CSOS has appointed 16 investigators, known as CEIs, as I said, compliance and enforcement investigators, field workers who go out on site to check up on registration. So they go through to complexes. And when I was at the CSOS 2 weeks ago, we saw one of the investigators who come in, and she's actually won awards for being CSOS awards at the CSOS events for being the top investigator. Also remember something in the directives, which I thought was interesting, is that owners in a scheme who are not happy that their scheme is not registered can whistleblow on the trustees by sending an NC1 form to CSOS, which alerts the investigators to investigate. Honestly, though, that approach is going to take another 20 years unless the bank approach is taken. I think it's time now. What is the situation if a scheme is not registered? The CSOS Act states that interest may be charged at the rate set by the National Credit Act, which is from the date that it remains outstanding, which is at the end of 2016. Remember that, arrear levies, they also talk about interest in terms of the National Credit Act. So what does that mean? It actually means the repo rate, which is the repurchase rate, plus 14%. So right now, the repo rate is at 6.75%, plus the 14% would leave us at 20.75% per annum. So that is what they talk about when they talk about the National Credit Act interest rate. Quick interlude here. When you register a scheme, a person must be appointed by the community schemes as an authorized representative, and this person's name must be minuted. So your scheme should know who the authorized representative is to CSOS. So it's a go-between between CSOS and the scheme. My question to you is, can a managing agent appear as the authorized representative? So please answer that if you know the answer so that I can come back and have a look. But we'll go on. We can all agree that registration is the gateway to obligation on all trustee rule enforcement. Governance hinges on registration. So calling yourself a village, as some complexes have that I've dealt with, or an informal commune doesn't cut it. Also, a critical governance point for me is that even if the managing agent handles the submission, and even if the managing agent is the authorized representative, the trustees remain legally liable and responsible for compliance. So write this down. You can outsource the admin, but you cannot outsource the responsibility. The directives again concretize our understanding that to register, you need at least 2 trustees, and there should be more than one authorized signatory for banking purposes. So Sharon answered my question. She says, I would say yes, as long as it has been done by resolution or by service agreement. Resolution is first option. 100%, Sharon, spot on. So managing agents are definitely liaisons between the body corporate and the Community Scheme Ombud Service. But as long as they know, and the trustees know, that the buck stops with the trustees, right? We go on, and if you're going through this after I've given this presentation and you're looking at your notes and you're looking at everything, we would be on page 39. And there's an Annexure A in the directives, which tells you exactly what documents need to be uploaded to register for a new scheme, an existing scheme, for new developments, for dual schemes, remember duets, and for mixed use developments. So another thing to keep you on your toes, another question here is, can the CSOS refuse to hear a dispute if the community scheme in which the dispute is taking place is not registered? Is not registered. We had that actually in one of the cases. Can the CSOS refuse to accept a dispute if the scheme to which the dispute relates is not registered? Okay, Sharon again. Sharon is on the ball this morning, but this answer is not correct, Sharon. You say yes, they can't. The CSOS has to resolve disputes, doesn't matter if the complex is registered or not. That is their separate mandate to go out and check if complexes are registered or not. It might give the investigators some information that they can go out, but they're not allowed to stop the dispute. No, they can't. They can't. Janet and Sharon, they can't. Can trustees be sued in their personal capacities if they don't register their scheme? Can trustees be sued in their personal capacities if they don't register their scheme?
Yes.
Yeah, absolutely they can. Because non-registration is not an admin error. It's a governance failure. And in terms of your fiduciary duty to act in good faith, with care and skill and due diligence, yeah, you will be sued. And that's in your personal capacity as a trustee. Okay, then there's number 2. We talked about registration. Now we're talking about compliance and enforcement. The CSOS here sets out 4 directives in crucial areas: registration of the scheme, submission of annual returns, quality assurance of all scheme governance documents, and arrear levies, payment of levies. The directives now are at pains to emphasize that the CSOS is willing to engage with registered schemes that require guidance and support, and will go out to schemes where possible. In fact, when I was at the CSOS, the lady, one of the governance officers, was actually going to Rustenburg on a weekend to go and sort out some issues there. And also not only to endeavor to provide training and guidance, but also to monitor a scheme. So CSOS officials have been known to sit with schemes, help them and say, right, from this point, let's go forward. Let's see where you are. Have you done your reserve fund? What is happening? So they've got a much bigger role than I think we think they've got. Mediation, intervention, and on-site verification are all steps taken by the CSOS to enforce compliance. Self-managed schemes are not exempt from compliance verification processes, and a CSOS investigator may at any reasonable time and with prior notice conduct a compliance monitoring process to assess compliance and practice. Also, intentional non-compliance is viewed in a very, very dim light in terms of these practice directives. Okay, so if it were up to me, the National Prosecuting Authority would get involved a lot more, but let's see, when can they get involved? Firstly, when there's a failure to provide access to any books, accounts, documents, or assets when required to do so under the CSOS Act. When there's failure to comply with the directive, everything we're dealing with now, when you don't comply, and as a managing agent, when you don't comply, the National Prosecuting Authority could also step in. Failure or refusal to give access data or information, or giving false or misleading information, intentionally refusing to perform a duty or obstructing any person in the exercise of a power in terms of this act could lead you to the National Prosecuting Authority. So non-compliance is dealt with, if you want a section of the CSOS Act, it's section 34, and there you can find the fine and imprisonment regulations. So imprisonment is quite interesting because they say that if there's a first breach of all those failures that I've just spoken about, you could have a 5-year prison sentence. If it's a second breach, then you have to go away for 10 years. So yeah, we have to be a little bit careful about that. But at this stage, I don't think anyone's going to jail. A great resource, which I'm hoping that you'll value and use in the directives after Annexure A, is the process flow, which is a fabulous reference schedule taking you through every step of the registration process, through every step of lodgement of rules, and also registration of new developments. The question here is, if the applicant is trying to register a scheme but doesn't have the establishment date of the scheme, what date can he or she enter? And I'll answer that for you. That would be the 7th of October 2016. When in doubt, put that date in terms of the, especially on CSOS Connect. CSOS Connect, and they've mentioned to me again when I was there that CSOS Connect is a problem. There's no doubt there are still issues, not 100% yet, but they are really pulling out all the stops to make sure that it's working. Now that was chapter 1. So we passed chapter 1, now we're going on to chapter 2, and that's scheme governance. So funnily enough, the first point under governance in this chapter deals with disaster management. Under the Disaster Management Act, CSOS can cater for instances where a national disaster is declared. So where a state of disaster at national, provincial, or municipal level is declared, and such declaration has a direct impact on the community schemes, The trustees have to adhere to this directive. But remember always that any Disaster Management Act regulations, they will prevail over any legislation, even sectional title legislation. If there's a conflict, Disaster Management Act wins. Then it goes on to discuss under DMA, Disaster Management Act, discusses trustees meetings and gives options for trustees to use either the DMA regulations or our standard management rules. I would always say you stick to the management rules. You can use the telephone as a trustee or virtual, any other method, as long as the method is accessible to everyone and as long as the parties on the call or on the virtual computer system are identifiable. And we know that that's Management Rule 11.5, right? Also, owners' meetings. With both AGMs and special general meetings, 17.2 and 17.9 management rules, you can waive the AGM within 1 month of the financial year end, as long as written consent is given by the owners for all the motions, the resolutions, in other words, that are tabled. So that's important. A nice refresher for you guys. I had a situation once where it was at an annual general meeting. It wasn't at an annual general meeting. They didn't want to call an annual general meeting. So there was written consent given from all the owners, but they were joint owners of one unit. And only the one owner gave written consent to waive and to pass the resolutions. And the caveat in the management rules is that both joint owners, or if they're 3 owners or 4 owners, they all have to sign consent. I don't know, just something interesting. Okay, let's just see. Sharon, a side question regarding the different acts. There was no mention of the FICA Act. How does this play a role in the administration, as managing agents will rely on the attorney to provide documents? Surely the body corporate, via the managing agent, should be verifying this information. Yeah, I think you're right, and maybe it's an omission on their part, because FICA certainly does play a part, and I can honestly tell you that for attorneys now, FICA is becoming a massive problem, because let me just explain to those people who are not in the know about this, is that when we were on the grey list, when South Africa went onto the grey list, we had to get off the grey list. So President Cyril Ramaphosa approached the FICA, and the FIC made regulations which apply to us to say that as attorneys, if we get clients, we have to rate those clients. We have to get all the information, but we also have to ask questions like, are you politically affiliated? Where does your money come from? And we have to rate those clients, which has been a real bugbear. And that got us out of the grey listing now. So yeah, I agree, Sharon, definitely. And I think the body corporate should be, via the managing agent, verifying all information that is taken through the FIC, 100%. Health and safety, just to go on quickly, community schemes must ensure, this is under the Disaster Management Act, ensure the safety of the employees during the state of disaster. Providing mitigation kits, safety notices must be visibly displayed at entrances, and biometric systems should have been suspended. And obviously, people limited on common property, and due to negative impacts on the economy, trustees would have needed to enter into payment arrangements. I think this sounds ominously familiar to us when we went through COVID. This was the case, and I think that they needed to tighten that up in the practice directives, which they've done. Right, moving on. The next point, number 4, under Chapter 2, approval of special and unanimous resolutions. So the directive here is specifically dealing with Section 6.9 of the Sectional Title Schemes Management Act. You know, the section which says where a body corporate or an owner can't get a unanimous or special resolution, they can approach the chief ombud for relief. So in practice, it happens so often that a resolution like this is thwarted by 1 or 2 difficult owners, and the law now seeks to protect a scheme against being held to ransom by those 1 or 2 people. But there is a caveat which says that you can't go running to the chief ombud for a ruling to be substituting the failure to get a resolution. So for a unanimous resolution to be passed, for a unanimous resolution at first try, you would have had to get at least 75%. So you wouldn't have got the 100% of the 80% quorum. You would have got 75%. Then you can go off to the chief ombud quite happily. In the case of a special resolution, at the first meeting and at first bite, you would have had to get 50% in order to go and take the special resolution debate to the chief ombud's office. The form to fill out on CSOS Connect is form ST1. And again, it's noted here in the directives that the scheme governance officer cannot provide advice on the merits of the matter. So they can't say, yeah, I'm sure the ombud will overrule you because of this, that, and the other. The less they say, the better. The application form can also be typed or handwritten, provided that it's legible and easy to read. So what happens in a failed resolution situation? As soon as that resolution fails at that special general meeting, you've got 90 days within which to bring this application to the ombud. But condonation can be granted also by the ombud, where the supporting documentation is very important. So you would need the notice of the meeting. Was there a quorum? Who voted in favor? Who didn't vote in favor? All of that is exceptionally important. The SGO, so people think the chief ombud sits there and does all this work. Definitely not. It's a scheme governance officer who will sit and take these complaints. They'll ask for clarification. And one of the factors taken into account by the directive is that the SGO must decide whether the resolution will enhance the living conditions of the members residing in the scheme or promote proper governance in the community scheme. If that SGO rejects the application, then the applicant will be informed in writing and furnished with the reasons. Interestingly enough, this directive doesn't mention section 13.2, picks up, of the STSMA, where an owner has 6 weeks to approach the ombud for the ombud to declare it unfair and prejudicial that other owners are not consenting to change of use applications. So that's, for example, where you've got a guy with a garage. The use is obviously a garage, and he tries to have a little store or something which services part of the industrial development next door, whatever. I'm just giving you an interesting sort of example. But it doesn't talk about that, so I wonder why. Anyway, just going back to section 6.9, it is incumbent on the SGO to notify all interested parties about the owner or body corporate's application, and that is in terms of section 33 of the Constitution and the Promotion of Administration to Justice Act. The body corporate also has a responsibility to circulate the SGO's communications to all owners because it does affect them. They try to take a special resolution, or an owner tried to take a special resolution, and now somebody's challenging that. So everybody has to know about that. What happens if a party is unhappy, like the ombud, the SGO makes a decision and actually substitutes the failed resolution and says, yeah, you could get a unanimous resolution. It'll enhance the scheme if you got that unanimous resolution. Then the complainant would be able to take the matter on review. But that's to the High Court. Okay, so we have, Serena says a managing agent is a property practitioner and is an AI in terms of FIC. We should all have RMCP and doing TFS on all trustees. FIC did an audit on me. Geez, that's scary, Serena. I'm a bit nervous to see what they found out about you. But thank you, and thank you for all those acronyms. I appreciate it. I hope your managing agents all know what you're talking about there. Interestingly, for a law firm that didn't comply with FIC and just went on in the normal course, there was a 7 million rand fine that was given to that law firm. Yeah, so they're serious. They really are. That brings us to the end of Module 1. Next time in February, we're going to be dealing with rules, unreasonable rules. We're going to be dealing with how to lodge the rules. Also, we'll look at annual returns, and then Thirdly, we're going to do dispute resolution. So by the end of March, we are all going to be absolute experts in the Consolidated Practice Directives. Nobody is going to be able to ask you any questions without you knowing the answers. And you know what? That really makes the difference and the distinction between us being good at what we do and being great. So thank you again. ASI Besture, welcome. We appreciate you and we connect you. I'm certainly going to see you on the Engage online web event on the 6th of February. And I hope that all of you will take this opportunity to learn more and to engage with our industry just to get stronger and stronger. So thank you, and we'll see you next in February.